Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Murder is a pretty awful thing, and I personally find murder for profit to be about the worst thing possible. While the folks at Purdue Pharma may not have started down the road of murder for fun and profit, at the end of the day, that's really kind of where they wound up. And yeah, maybe murder is a little harsh. Maybe you could consider it involuntary homicide, and maybe even that is a little bit of hyperbole. But in some respects, when you trade lives for money, most reasonable people would consider that to be some form of homicide. So today we're talking about Harrington, United States Trustee, Region 2, versus Purdue Pharma. And it is a case that reached the United States Supreme Court, and that's a really good thing. So, according to the Supreme Court's opinion, between 1999 and 2019, approximately 247,000 people in the United States died from prescription opioid overdoses. Now, the respondent in that case, Purdue Pharma, sits at the very center of that crisis. Now, Purdue Pharma was owned and controlled by the Sackler family, which is a fairly extended family. And when Purdue began marketing a drug called OxyContin, it was an opioid prescription pain reliever. It was in the mid-1990s. It was a very popular drug because it was very strong, it was an opioid, and like all opioids, not only did it reduce pain, but it also provided some form of euphoric high. After Purdue earned billions of dollars in the sales of the drug, in 2007, one of its affiliates pleaded guilty to a federal felony for misbranding OxyContin. And how did they misbrand it? They misbranded it as a less addictive, less abusable alternative to other medications. In other words, branding it this way would encourage doctors to prescribe OxyContin instead of other harder narcotics because they might not get as many people addicted to opioids. But the laugh was on the doctors because OxyContin was exceptionally addictive. So after they pleaded guilty to that, thousands of lawsuits followed. Fearful that litigation would eventually cause them to go belly up, the Sacklers started what they called a milking program. They started withdrawing from Purdue approximately $11 billion, or 75% of the firm's total assets, over the next decade. Now, if that's not enough to make you hate Big Pharma and be disgusted with the whole industry, I don't know what is. Yet, it gets worse. Those withdrawals from that milking program left Purdue in a weaker financial condition, and the opinion says it was significantly weaker. So, totaling up all the cases that were filed and the likely cost to defend each and every one, even in multi-district litigation, produced an eye-popping number. Now, why would that be? Because if you've got 10 plaintiffs and they all sue for injuries or death caused by OxyContin, well, you have to file an answer in every one of those cases. You have to file a motion to dismiss in every one. You have to answer discovery. You have to request discovery and evaluate it. You have to evaluate the strength of the case, and you have to do it individually for every case. So every case gets at least one and usually two of its own lawyers, and they start billing probably at $500 to $700 an hour. And once the meter goes down on all of those cases, irrespective of whether they have enough money to pay the damages, the real question may be, do they have enough money to pay the actual lawyers who are defending the cases? So in 2019, Purdue filed for Chapter 11 bankruptcy. Now, Chapter 11 is traditionally thought of as a reorganization bankruptcy. The idea is to restructure and reorganize the debt so that the entity can continue to operate as a going concern. But that was not going to happen. During the process, the Sacklers proposed to return approximately $4.3 billion, or less than half of what they'd taken out, to Purdue's bankruptcy estate. But that was not a show of remorse or good faith. Nope, because what the Sacklers wanted in return for that donation was complete and total absolution. In other words, they wanted to place all of the liability for everything on the Purdue Pharma entity, and then they wanted no litigation against them. All the lawsuits that were filed and that named them as well as Purdue, they wanted them to go away, drift off into the ether, and if you get any money, you get it from Purdue. So $4 billion is the carrot. And you got to admit, that's a pretty big carrot. But it's not even close to what the actual liability would wind up being in this case. But if that was the carrot, then you had to wonder what the stick was. Well, here's the stick. If they didn't get it, the $4 billion that they offered wouldn't get paid, and there'd be basically no fund for all of those plaintiffs to be compensated from. As my friend Tony Two Toes would say, nice lawsuit you got there. Be a shame if something happened to it. And that kind of is what happened. So the Sacklers in the bankruptcy, through their attorneys, sought a judicial order releasing the family from all opioid-related claims and enjoining the victims from bringing any lawsuits against them in the future. So current claims, dismissed. Future claims, barred. Now, a bunch of parties to the bankruptcy objected. They said, hey, you can't do that. If they want protection under the bankruptcy court, they have to file for bankruptcy themselves. Well, one of the objectors was Paul Harrington, the trustee for the United States. Now, the U.S. trustee is the person who is there to try and keep the playing field level, ensure that everyone is playing fair. Now, in a bankruptcy, you have all kinds of committees, and one of them is the creditors committee, and each creditors committee, a lot of times you'll have multiple creditors committee. For example, if you have people who hold secured notes or secured loans, they're a different form of creditor than people who are suing for relief. So if Purdue, when they set up a factory, they signed a note for $10 million to Acme Finance. Well, Acme Finance is a secured creditor, and they stand head and shoulders above these lower plaintiffs who are essentially suing for damages. So there's all kinds of different committees, and many of the committees wanted this to go through, so they didn't object. Not only did they not object, many of them filed paperwork in support of the Sacklers' motion. But several didn't, and the U.S. trustee decided that he wanted to object. So they objected that giving them a free pass was nowhere contemplated in the bankruptcy code. So if you go and you read the entirety of the bankruptcy code, nowhere in it will you find a provision that says somebody who is a third party to the bankruptcy can have all of their debt wiped out too. Again, because that would defeat the whole purpose of bankruptcy. Bankruptcy is to get a release from your debt, but you do it by throwing everything that you have, pretty much everything you own, into the mix, and then letting people, negotiate for what they get. Well, bankruptcy judges are not appointed by the president, nor are they approved by the Senate. In spite of this, they wield enormous power in this process. And by enormous power, I mean they can do things that even some federal judges can't do. While they're supposedly supervised by district courts, who are Article III judges, who have been appointed by the President and confirmed by the Senate. In practice, the supervision is minimal. If an objector files an objection and the bankruptcy judge denies the objection, in theory, the objector can appeal. And this is in the middle of a bankruptcy. If you have a claim that you advance and they deny your claim, you can object and you can appeal that. In practice, at least in Delaware, where I was part of a bankruptcy case, I was arguing on behalf of plaintiffs who had sued. In practice in Delaware, the bankruptcy judge does what he does, knowing that by the time the district court gets around to ruling on the objection, the case will be closed. So over the objection of the parties, the bankruptcy court approved Purdue's proposed reorganization plan, including the provisions that gave Sacklers a discharge, wiped out their debt. Now, incredibly, the district court, and this of course is in New York, it's not in Delaware, it's in New York, the district court vacated that decision. And it said, nothing in the law authorizes bankruptcy courts to extinguish claims of third parties, like the Sacklers, without the claimant's consent. So that went up on appeal to the Second Circuit. And the Second Circuit reversed the district court and revived the bankruptcy court's order approving a modified reorganization plan. So the New York courts applied a higher level of scrutiny than did courts in Delaware, and kudos to them for that. And in this case, it was the Second Circuit that dropped the ball. So the trustee took it up to the United States Supreme Court. And here's what the SCOTUS said. They said the bankruptcy code doesn't authorize a release and an injunction that, as part of a plan of reorganization under Chapter 11, effectively seeks to discharge claims against a non-debtor without the consent of the affected claimants. So if you want to get this kind of discharge, what you have to do is you have to come before the bankruptcy court and you have to allow anybody who has a claim against you to either consent or refuse. And anybody who refuses, their claim's not going to be wiped out. Now, could you wipe out a lot of them that way? Perhaps, but in practicality, it's not really going to work. So, much like when a person dies, the probate court creates an estate for all their worldly holdings. When a debtor files for bankruptcy, it creates an estate, and that includes virtually all of the debtor's assets. Stocks, bonds, notes, accounts receivable, all of those things get dumped into the big pot, and then that's divided up amongst the creditors. Under a Chapter 11 plan, the debtor has to develop the plan governing the distribution of the estate's assets and present it to the bankruptcy court for approval. Now, in a Chapter 11 proceeding, the people who do this are the people who run the company. A bankruptcy court's order confirming a reorganization plan then discharges the debtor of certain pre-petition debts. So in this case, the Sacklers had not filed for bankruptcy or placed any of their assets on the table for distribution to the creditors, yet they sought what essentially amounts to a discharge. And there is nothing in the bankruptcy code that authorized that kind of relief. Now, the court dealt with all the proposed ways in which a release could be effected, including the multiple asserted statutory bases that all of these lawyers representing Purdue Pharma came up with. And the Sacklers tried to ram this through under a statutory catch-all, and the court said no. So when that didn't work, they defaulted really to arguing policy. The Sacklers said they will not return any funds to Purdue's estate unless the bankruptcy court grants them the sweeping non-consensual release and injunction. Without the discharge, they predict victims will be left without any means for recovery. Nice lawsuit you got there. Again, shame anything might happen to it. But the U.S. trustee disagrees. As he tells it, the potentially massive liability the Sacklers face could very well induce them to negotiate for consensual releases on terms much more favorable to all of the claimants. In other words, if they want protection, they're going to have to come into bankruptcy court and ask for it. In addition, the trustee says, look, if you allow this to happen, you're granting a roadmap to all the different tortfeasors to use bankruptcy to wipe out not only the debt of their company, but anybody else like the CEO and CFO and people who are major stockholders. You're asking the court to make that a common practice in bankruptcy. So while both sides have their points, the court said, look, this is the wrong audience for policy disputes. Policy disputes, you take those to Congress. Our task is to interpret and apply the law, and nothing in the present law authorizes the Sackler discharge. The court went on to clarify that it was ruling on this case and only this case. It said its decision was a narrow one, and that nothing in the opinion should be construed to call into question consensual third-party releases offered in connection with a bankruptcy reorganization plan. The court didn't express a view on what qualifies as a consensual release or pass upon a plan that provides for a full satisfaction of claims against a third-party non-debtor. Additionally, because the case involves only a stayed reorganization plan, the court doesn't address whether its reading of the bankruptcy code would justify unwinding reorganization plans that have already become effective. And of course, that is a huge problem because, as the courts in the Third Circuit say, you can't unscramble an egg. And if you've already started releasing assets to creditors, there's not going to be anything left in the pot. You can't go back to those creditors and make them put the money back in and redo it. So again, that's what they call equitably moot, and it doesn't work. You can't unwind a reorganization plan that's already become effective. So they confine themselves to the question presented, and the court only holds that it doesn't authorize these third-party releases. So, because the Second Circuit held otherwise, its judgment was reversed, the case was remanded, and who knows what's going to happen. I don't know what the Sacklers are going to do. I would assume that they will try something to get out of this, but I don't know exactly what that will be. There's a big push by the plaintiffs' bar to go after the family and recover all the funds they stripped out of that firm. While New York law is not necessarily favorable in some respects in that regard, the equity of the situation may require the courts to bend a little bit on that. So this is one of the cases the Supreme Court got right. Hopefully you found this interesting, perhaps even useful. And if you have any questions, drop them in the comments down below. Like, share, subscribe, all that stuff we ask you to do. In addition to leaving your comments below, you can also email me at the address above. And of course, if you have a suggested video, I'd love to hear it. Just put up there, like it says, video request in the subject line. That makes it easier for me to find in all of the email that I get. And I do get quite a lot of email at that address. So if for some reason you haven't heard from me, send me a second email. I'm sorry, but I'm only one guy. I'm not a big corporation, so I don't have staff. I'm the staff. Thanks again for watching. If you have the opportunity today, do something nice for someone because it makes the world a better place. And then come on back tomorrow, join me down here at the beach, and we'll talk about something else interesting. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.